Week 1 has just finished in the jury trial for the killing of Ahmaud Arbery, and I'm here to give you a legal recap. Let's talk about the good, let's talk about the bad, but let's also talk about the ugly. There are so many issues that have already come up, and it's only the first week of trial. The lawyers in this case, they anticipated going for about 3 to 4 weeks, and I will be giving you a legal recap at the end of each week. So if you don't have the 100 or so hours to sit around and watch the entire jury trial, here's a 15-minute breakdown of everything that happened in week 1 coming up. Hello, my name is Clyde Guilamo, and I am a lawyer in the Chicagoland area. And in Law Talk for Non-Lawyers, we talk about the law in plain English. And in this video, I'm going to provide you a legal recap of the first week of the jury trial in the killing of Ahmaud Arbery. Viewer discretion is advised because this is a homicide case, and those are the topics that we are going to talk about. I've divided this video into 3 parts. The first part is talking about the jury selection process and everything that happened there. Secondly, we're going to talk about the opening statements and how the lawyers did. And lastly, we will talk about the first witness and what issues came up with the first witness. So let's get started. All right, so let's start off with jury selection. In every criminal case, a defendant has the right to a jury trial by either a judge or a jury. And that right to a jury trial is something that's actually governed by the 6th Amendment of the United States Constitution, which is applied to the states by the 14th Amendment, okay? But when people receive that jury summons, it's not the case that the first 12 people to walk in are the first jurors on your case, okay? There's a good reason why both sides may not want prospective jurors to sit as a juror on their case. And let me give you some examples. If this were a drug delivery case, it might be the case that the prosecution would not want people who are sympathetic to drug dealers on their case. So maybe he would not put on the guy from Breaking Bad, or maybe he wouldn't have El Chapo sitting as a juror in that case. Whereas the defendant may not want certain individuals as a juror on their case. For example, the father of a child who died from drug overdose. Okay, that's going to be someone that a drug or someone accused of dealing drugs wouldn't want that person sitting on their jury. Now, these are great reasons to remove a prospective juror for cause. However, there's also an ability for lawyers to strike people for things that don't actually rise to the level of cause, okay? So if you're the prosecutor and you see someone wearing a band shirt that's an anarchist band, Raging Against the Machine band or something like that, those are kind of jurors that you may not have for cause to remove them, but you would still want to get them off your case, okay? Or if you're a defendant and you see someone who comes in and they were wearing like a Dare shirt or a Great shirt, one of these programs that really teach kids about not using drugs, these would be the kind of shirts that a defense attorney would say, whoa, I am going to knock this person off of my jury if they're going to come to jury selection wearing a shirt like that, okay? So you can just say, I want to use one of my preemptory challenges and take this particular person off the case, and you don't have to give a reason. Up until 1986. What happened in 1986 was this. There was a criminal defendant in Kentucky. His last name was Batson. He was charged with a burglary, and he had a jury come in for the jury selection process. What happened was the prosecutor eliminated all black people from being prospective jurors, right? They used their preemptory challenges on all the African Americans who came in for jury selection. So what Batson said, hold on a second, the entire jury who's going to be looking at my case is not of my peers, it's just white people. And he said that this was not fair to him. Well, unfortunately, he was found guilty, and that case went all the way to the Supreme Court, and the Supreme Court sided with Mr. Batson. They said, hold on a second, you cannot remove people solely on the basis of race. that has since been expanded to include gender and other protected categories, okay? So there is no longer an ability for lawyers to exclude people just because of these protected categories, may they be race, may they be gender, etc. So now we get to Ahmaud Arbery. There were 12 prospective jurors that came in that were African American or black, okay? Of those 12, 11 of them were knocked off by the defense. So the prosecutor raised a Batson challenge. Now, a Batson challenge is twofold. The first step is to show whether or not there's a prima facie case of discrimination of jurors on the basis of race, okay? And what the prosecutor mentioned was, look, of the 12 prospective jurors that were black, the defense has knocked off 11 of them, and the court ultimately held, yes, I'm gonna find that they've met their prima facie case. There seems to be a pattern of knocking off black jurors from this jury, okay? So then it goes to the second part of a Batson challenge, and that's ultimately for the other side to give a reason as to why they knocked these individuals off, okay? And if that reason has to be a race neutral or gender neutral reason as to why they're knocking these individuals off, and that what was given by the defense. They gave the reason as to why they knocked off those 11 prospective jurors. Now, after the defense gives that reason, the judge has to make a determination. Am I gonna find that they were discriminating against black people on this jury, or am I gonna find that their race neutral reason is enough to justify the knocking off these individuals from the case?
This court has found that there appears to be intentional discrimination in the panel. That's that prima facie case. State of Georgia, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. And the court is not going to place upon the defendants a finding that they are being disingenuous to the court or otherwise are not being truthful with the court when it comes to their reasons for striking these jurors.
And what the judge decided was that their race neutral reason was enough, okay? Although initially it did in fact look like discrimination, the judge said, well, that's actually a race neutral reason for why you would not want these individuals on your jury. And therefore the case was able to proceed. And we're gonna talk about our next step, which is opening statements. All right, so let's talk about opening statements. Opening statements are the opportunities for the lawyers to go ahead and express to the jury what they believe the evidence is going to show, okay? There's only two opportunities that the lawyers get to speak directly to the jurors. That's in opening statements and in closing arguments. So it's very important that the lawyers do a good job. So let's go ahead and look at a piece of each lawyer's opening statement and talk about whether or not the lawyers did a great or poor job. Now, before we get into this, I just want to say these are some of the better lawyers out there, okay? So this is, if this were football, we would be talking about like the Tom Brady's, the Brett Favre's of the world. So as I'm critiquing them, just know that this is critiquing some of the best and not your middle of the road lawyers, okay? All of these lawyers do a good job of going through the structure of an opening statement, talking about the things that they should be talking about the opening statement, okay? So I'm not gonna repeat all of the basics of what a lawyer should or should not do. These guys are knocking those items out of the park, but I will critique them as to how they do certain things poorly and how they do other things better. So let's go ahead and look at the first opening statement, which is the prosecutor. It is the state's burden to prove these three co-defendants guilty, and here we have Linda Dunikowski. She's gonna go ahead and give the opening statement on behalf of the state. So let's go ahead and watch.
Good morning, ladies and gentlemen. Good morning. My name is Linda Dunikowski, and I, along with Larissa Olivier and Paul Camarillo, represent the people of the state of Georgia and the citizens of Glenn County. Why are we here? We are here because of assumptions and driveway decisions.
All right, let me just go ahead and say off the bat, I am not a fan. I am not a fan of this opening statement. I wish she would have done a much better job. Now, here are two big problems that I have with this opening statement. First, Why are you introducing yourself at the beginning of the opening statement? This case is not about you. Who cares who you are, Linda? We care about the victim of this case, Ahmaud Arbery. You should have went ahead and started off with Ahmaud Arbery and talking about him as a victim, him being gunned down, him just being an innocent civilian who was just minding his own business, okay? You should have started with your victim. Take yourself out of this. It's not about you. It's about your victim. Come on. I wish the state would have done better. The second big issue that I saw with the state's opening is the fact that they made their theme about driveway decisions and assumptions. What? Come on. You're dealing with a homicide case. You should be dealing with your victim. Your victim should be front and center, and this is just horrible. Really bad job by the state choosing a theme that sucked, not talking about the victim coming out the gate, introducing yourself when this case is not about you. Come on, state. I am not giving them high marks for this opening statement. They could have done a much better job. Let's go ahead and look at the defense's opening and see if they did a better job than the state. Now, here there are 3 defendants, and let's talk about the first defendant, all right? Travis McMichael. He's the younger one of the 3. He's the one who you see out on the street tussling over the gun with Ahmaud Arbery. His lawyer, Robert Rubin, gave an opening statement. He was the first criminal defense attorney to give an opening statement. So let's see how he did.
Good afternoon. For those of you who may not remember from 2 weeks ago or whom I never met, my name is Bob Rubin. And along with Jason Sheffield, who I think y'all met, we represent Travis McMichael. What we're asking you to do is hard. And it may be unpopular. But we're asking you to recognize your responsibility as jurors in being open to the facts and putting aside emotion and listening to the law.
Once again, I am not a fan. I'm sorry, guys. I am not a fan. This is just my personal opinion, but I do not like how they did that opening statement. First things first, this isn't about you, okay? Like, get the intros out of the beginning of your opening statements. Like, focus on who you need to be focusing on, which is your client. You should be focusing on your client. And then even worse, towards the end of his opening statement, he's talking about how much of a hard decision this is going to be. Like, why would you go ahead and tell a jury that what you're asking is a hard decision? Don't you think that you should be doing the exact opposite, okay? That you should be telling them, hey, this is an easy decision. This thing is on video. You're going to be able to see with your own eyes how Ahmaud Arbery was lunging at my client, how this is a case of self-defense. This is going to be clear as day when you watch that video, okay? Like, that's what you got to be telling your jury. Not that they're going to be making a hard decision. Come on, man. Like, these are bad mistakes that these lawyers are making. So I'm going to go ahead and say I'm not a fan, okay? I think that he could have done a better job with what he had, and I don't think that he did what he should have done, okay? Let's move on now to the next co-defendant, which is Gregory McMichael and his lawyer, Frank Hugh. He also gave an opening statement, and here it is, parts of his opening statement.
Greg McMichael was absolutely sure. He was absolutely certain. And he was absolutely right. The guy he saw was the guy he suspected. He's on the phone. He's describing to the person at 911 where they are best he can. He doesn't even know the name of the street. He just tells them Satilla Shores near his house. And then you hear him, as Ahmaud gets close to the back of the truck, you hear him yell, "Stop right there. Damn it. Stop." And then the next thing you hear, and the last word you hear him say on that phone is, "Travis." Because by then, Greg has turned as Ahmaud Arbery is running past the truck, and he sees him turn towards his only son. He drops that phone to the floor of the truck, in the bed of the truck. He's now in abject fear that he is about to witness his only son possibly be shot and killed in front of his very eyes. The what happened in this case will, for the most part, though there will be some dispute, but for the most part, be without dispute. The facts, the what happened in this case. The why it happened is what this case is about.
All right, hands down, the best lawyer to give an opening statement is our guy Frank, okay? He doesn't go ahead and start off with some crappy introduction like the other two did. He goes immediately into what is obvious, what his client knew, and he's really reframing the case so that he can tell his narrative about how it's easy. You're gonna watch this on video, so the only question is really gonna come down to is what my client knew at the time and what my client was thinking. Perfect. He did a much better job than the other two lawyers. They should be taking note. Frank was the best lawyer of the three who gave an opening statement, okay? If I had to rank them, clearly he would be in first place because he did such a great job. I would probably put the prosecutor, Linda, in second place. And lastly, I would put Robert in third place, okay? All right, now let's talk about the fourth opening statement that did not happen, okay? Now, that was the attorney for the last defendant here, which is William Bryant. His attorney, Kevin Go, decided to not give his opening statement at the beginning of the case. Now, let me talk to you how a case works. So first, the prosecution puts on their case in chief, and then the defense gets to put on their case in chief or their evidence, their witnesses, okay? So you can give an opening statement either at the beginning of the case, or for the defense, you can give it at the beginning of your case in chief. And that was the decision that Kevin made in this case, okay? Now, what are some of the benefits of making that unorthodox decision, because it's not the common practice, is this: you get to give your opening statement, you put on some evidence, and then you'll get to give your closing statement shortly thereafter. So you get two bites at the apple in a very narrow period of time, okay? It's kind of like the way the state gets a opening closing statement and then they get the rebuttal close. This lawyer now can do his opening statement towards the end of the case and the closing. But here's the downside, okay? The state has just casted the narrative of how this happened, and now the jury's not going to hear your version of the events until halftime. You better hope that they haven't already formulated their opinion of what actually occurred during the state's case in chief without you first having an opportunity to express yourself, okay? There's some psychologists out there that would have said that this is a bad move, but otherwise, hey, you know, I don't know. I'll put it up to you. Would you say that it was better that that defense attorney, he decided to wait until the end or of the case, the state's case in chief, to give his opening statement? Or do you think he should have given his opening statement at the beginning with the other three lawyers who gave their opening statements? That's for you to decide, okay? But now let's talk about the sole witness who's testified thus far. So the decision to call witnesses in whatever order you want is really important to the state, okay? You want to go ahead and have one of your first witnesses be someone who can really give you an overall view of the case, okay? Someone who can give you a lot of information. Generally speaking, that would be the victim of the case. However, in a homicide case, you don't have a victim, so sometimes that's your first officer who arrives on scene and starts interviewing individuals, and that's what the state did here. They put on William Duggan. He's a veteran of the law enforcement department out there in Georgia, and he goes ahead and talks about what he observed, and let's look at a sample of that.
Junior on the side. Didn't know who he was at the time, but I could see he was covered in blood. There was blood all over, and I remember at some point asking if he was okay.
And what did that man covered in blood, seated over there, say to you when you asked him, "Are you okay?"
It was a quick reply of basically, "No, I'm not okay. I just effing killed somebody."
So this was a very good decision by the state to choose to put on an officer at the beginning of the case who would really give you exactly what he gave you, an admission by the defendant that they had killed this individual. That really takes some of the guesswork out here as to what happened. All right. Well, that is it. That is your recap of the first week of the jury trial for the three individuals charged with killing Ahmaud Arbery. please stick around. I'll be doing updates at the end of every week, providing you with specific details as to what's going on in the case. And ultimately, when we get the jury verdict, I'll go ahead and share that with you on this channel as well. If you haven't already subscribed, please subscribe to this channel and hit the like button. It really helps out this channel. And I'll see you next week when we talk about week 2 of this trial. Take care, guys. Bye-bye.